Welcome to another episode of Husch Blackwell's False Claims Act Insights podcast. I'm your host, Jonathan Porter. We're a month past the presidential election and a month away from inauguration. And after inauguration, there will be a significant transition in all executive branch agencies, including the United States Department of Justice. In fact, the Justice Department may be at the forefront of agencies that President-elect Trump has an eye on when he's thinking about major reform. Given that focus, you might ask what impact that could have on False Claims Act enforcement. That's a great question, one that we've heard from many clients over the last month, and today we're going to answer that question. We're going to talk about what happens during a transition in the Justice Department, what impact transition has on pending investigations, and what might happen in the upcoming Trump administration when it comes to False Claims Act enforcement. One of the big questions I have is whether we might see the Trump administration's Justice Department embrace the Zafarov holding of the Florida federal court that key TAMs are unconstitutional. What might that look like? Hot topics today on the podcast. So hot that we're going to split this episode into two parts so that we can cover a lot of ground. This is a hugely important topic, and I don't want to leave anything out, so you'll need to come back later to hear about our Zafarov predictions. Hot topics today on the podcast, and joining me on the podcast to talk about the future of DOJ and FCA enforcement is my law partner, Cormac. Cormac is a former federal prosecutor from the DC U.S. Attorney's Office, and at Husch Blackwell, Cormac helps clients with a range of government enforcement issues, including False Claims Act defense. I'd love to talk about all of the great work that Cormac has done for defense contractors under FCA investigation, and he's had a lot of great results for our defense contractor clients. But what I really want to highlight is Cormac's excellent work leading the firm's pro bono partnership with the Dr. Lorna Breen Heroes Foundation. Cormac works with the foundation to allow medical professionals to seek help for mental health issues without risking their medical licenses, which involves lobbying state governments to improve their laws to help medical professionals get the help they need. For this excellent work, Cormac was just awarded Husch Blackwell's 2024 Pro Bono Impact Award. It's a big deal here at the firm, and Cormac, I'm tremendously proud of the work that you're doing, both in the pro bono world and for our firm's FCA clients. So, Cormac, I'm glad that you're joining us on the podcast today to tell our listeners about what to expect with the upcoming administration turnover when it comes to FCA enforcement.
Thank you, Jonathan. I'm really glad to be joining you today. I am flattered by the shout out, frankly, for our pro bono work and the Lorna Breen Heroes Foundation. It's an amazing organization, and I certainly appreciate you recognizing them here on your podcast. I encourage anybody who's listening to go check them out.
Absolutely. And what we can do, Cormac, is we can link in the show notes. So if you're listening to this now, go in the show notes. You can read all about the foundation and the excellent work that they're doing. So, Cormac, as I just mentioned, we've heard from a lot of clients with questions about how the new administration could change the FCA landscape. Really good, thoughtful questions about the extent to which changed leadership at DOJ impacts specific investigations. Now, we're going to talk about some specific things that have happened in the past, but Cormac, it's probably best for us to start with a high-level overview of how changes in administrations actually impacts DOJ. Do all DOJ attorneys resign and the president or attorney general, they just hire all new attorneys? Do only some resign? Then generally, what happens to existing investigations when a new administration comes in? Get us started with some background information, Cormac.
Sure. Well, as you know, with both of us having worked at the Department of Justice, it is a giant organization. Last I checked, there are something like 115,000 employees. So no, not all of them are going to be turning over with the change administration. It's really only the top level, the most senior. I shouldn't say senior because seniority really doesn't have anything to do with it. It's the leadership of the organization that changes. So really there's two categories. One is political appointees and then career employees. The vast majority of DOJ personnel fall into that latter category of career employees. So, but when we're talking about the transition with the administration, like I said, it's really only the highest level at DOJ, the leaders that are political appointees. And these are almost certainly going to be turning over because, like the name implies, they're political appointments that are made by the sitting president. So these are the folks, these political appointees are the ones that you see on the news that are going through the whole Senate approval process. They're the names you're hearing come up most recently with President-elect Trump. is as he's proposing nominees for various government positions, there are a lot of the higher level that do make the news, but there are other lower level political positions that don't make the news as much, still in that bucket of political appointees. But focusing on DOJ, like I said, it's really only those highest level officials that will be turning over from the Biden administration and then coming in new from Trump administration. These are the leadership within DOJ. It's not, like I said, not connected to their seniority. It's just their leadership status. So it's important to remember that DOJ is a large organization that is based in DC. Main justice, as we call it, is in the District of Columbia, but it also has a footprint in every state. So each state has at least one U.S. Attorney's Office, and the District of Columbia has its own U.S. Attorney's Office. Each U.S. Attorney's Office has a U.S. Attorney. So all of those U.S. attorneys are also most likely going to turn over. There are some historically sitting U.S. attorneys that carry over from one administration to the next, but that's unusual. Each of those U.S. attorneys' offices have their own more localized, trial-focused areas of responsibility, but they're all part of the DOJ family. And again, it's that leadership level, the top band of leadership at the DOJ and at the U.S. attorney's offices that will be turning over with the new administration. So that's the political appointee category. The larger, much larger category are career employees. And that's what you and I were when we were at the U.S. attorney's office. What the name implies is what it is that if you're a career employee, you are there for what could potentially be your entire career. Lots of people, end up retiring as DOJ employees. It has nothing to do with who's in the White House and not subject to any kind of political employment. So that would apply to the line level attorneys that handle investigations that, on the defense side, that's who we're interacting with. It would also include paralegals and support staff and all the people that help DOJ do its business. So again, these are the people that provide continuity at DOJ functions, of an organization of 115,000. If every employee turned over with each administration, it would be completely chaotic. And DOJ just wouldn't be able to get any work done. And frankly, folks on the defense side, you would have an incentive to just run out the clock and wait for a new administration with every investigation so that while it might be good for defense, it's not great for governance in any event. So when we look at that and those larger category of career employees, we shouldn't expect any real major case-specific changes just because there's a new administration. Our cases that we're handling are generally going to keep going and continue to proceed. The investigations that exist now are likely going to carry on into the next administration unless something truly bizarre happens. And look, you never know. But most likely, the cases that exist today will continue to exist in January and February into the Trump administration. The reason for that is that most DOJ investigations, and let's focus on FCA cases, those FCA cases are fraud investigations. And so in general, both political parties are anti-fraud, right? I mean, that's a category and an issue that is bipartisan. And so the FCA, or the False Claims Act, is largely viewed by the public and by government officials on both sides as being an effective and useful anti-fraud law enforcement tool. In fact, the most vocal supporter of the FCA in Congress is Republican Senator Grassley from Iowa, who has been on record for decades as being a champion for the False Claims Act and making sure that it is robust and maintains a valuable tool for law enforcement. So I don't expect that either party, whoever's in the White House or whoever's holding the levers of the Justice Department is likely to gut the False Claims Act. And if suddenly FCA cases were to dry up for some reason, like alluding to the Zafarov case that you're talking about, I would expect that senators like Senator Grassley and others in Congress would frankly go ballistic and start hauling DOJ and White House officials in for oversight investigations. So by and large, there may be some tinkering with it, but I don't expect it's going to be a wholesale change. Again, because the statute's been around for so long. Now, anybody who's watching the news knows that incoming President-elect Trump has signaled a strong desire to shake up DOJ. What that's going to mean remains to be seen. It's also clear that the last few elections at the presidential level have been deeply polarizing the country. So while we could see more turnover than usual at the line attorney level of those career employees, some of whom may or may not have a fondness for the incoming president, that may happen. But I think there's also a long line of lawyers out there who would love to have those jobs. And so DOJ is going to fill the positions. If a departing attorney decides to leave for whatever reason, the caseload remains. And so a new attorney is going to come in and take it over, which is why, again, in the big picture, I expect that the vast majority of cases that exist today, that are ongoing today, will continue into the next administration.
Thanks, Cormac. Yeah, I agree with everything you just said. I was at DOJ during the transition from the first Trump administration to the Biden administration. We had very little turnover at the line attorney level. Our Senate confirmed U.S. attorney resigned, but I think just about everyone else stayed. That's the way it normally works. There's a lot of continuity at the Justice Department because exactly what you just said, Cormac, if there was wholesale turnover, those under investigation would have a lot of incentives to just run out the clock, like you said. And that's just not the way it works. And then honestly, just thinking about the way our justice system should work, you shouldn't want people to be able to just run out the clock when things happen. There should be a lot of continuity so that people who do bad things, that the human traffickers and the like, that they are being held accountable and that justice isn't administered just during certain years. So, Cormac, rather than case-specific changes, to me, what's far more common in my experience in changed administrations is two things: changed priorities and changed policies. And that's where I think we'll see noticeable differences in the next administration, not on specific cases, but on priorities and policies. And Cormac, I think it'd be helpful for us to talk through the last three administrations and highlight the biggest FCA policy or priority changes that we saw. So let's go chronologically, starting with the Obama administration. To me, Cormac, the biggest FCA policy shift in the Obama administration was the Yates memo, named after my fellow Georgian Sally Yates. Cormac, start this history portion of the podcast by telling our listeners about the Yates memo.
Certainly, and completely agree that that's kind of what happens, is that policy level is where each incoming administration kind of wants to make their mark and influence how the DOJ is going to operate, but it's typically at the higher level. So like you were saying, what we tend to see with changes in administrations is that those higher level priorities may be adjusted. And the Yates memo, when it was issued, caused a lot of buzz. It was, frankly, our conversation illustrates that we're still talking about it here today in 2024. It's still front of mind for defense attorneys like us who deal with federal government investigations, just because it did put a different focal point in the way that the federal government was running their investigation. So as background, the Yates memo issued back in September of 2015. Sally Yates, as you said, was the Deputy Attorney General at DOJ. That means that she was basically the number two in command at DOJ. She reported directly and only to, well, I shouldn't say only, the president, of course, but within DOJ, she reported to the Attorney General, was responsible both civil and criminal law enforcement, and the FCA falls on the civil side. So the perception at the time, the sort of where did this memo and this policy shift come from, really came from the fact that we were on the downhill side of financial crisis, and there was just a lot of dissatisfaction and unhappiness in the country, frankly, that so many of the big banks and mortgage lenders and companies that had gotten bailouts and had contributed to the financial crisis, but few of the people within those organizations had actually gotten penalized or investigated by DOJ. And so really the Yates memo was trying to address that issue. And what it did was change that priority to look at the fact that these larger companies' investigations may have been forced to pay fines, and shareholders were losing money and employees were getting laid off. But the senior executives that ran those companies and made the decisions that led to some of the problems were not getting punished. So what the memo was doing is trying to get DOJ attorneys and these career line attorneys that you and I have been talking about, setting a policy change to have them focus on, in a corporate investigation, not just the company and what is the company doing, but what individuals within the companies or within the banks or the other organizations were themselves accountable and should also be treated as being part of the problem. And in the FCA context, what that meant was looking at individuals' leadership within companies and perhaps them being targets of False Claims Act complaints and then reaching settlements with those individuals in addition sometimes to the companies. So the memo got so much attention among the defense bar, people that do what we do now, because it meant that companies were potentially going to be required to push specific employees into the bullseye of a DOJ investigation. And the incentive, if you can think of that as being an incentive, the reason that a company would do that is because companies that are under investigation are looking for what is called cooperation credit. And so what that means, and it's kind of a fuzzy amorphous concept, but it generally translates during an investigation to the company trying to get a lighter punishment or a less severe consequence for any bad conduct if the DOJ investigators believe that the company has fully cooperated and shared information. So what companies are looking for when they talk about cooperation credit is it's kind of an amorphous concept. Generally translates to the company trying to get a lighter or less severe punishment if it can demonstrate to the investigators that it's been cooperative, that it's sharing information and trying to get, solve whatever problems the government is seeing. Under the Yates memo, the DOJ line prosecutors were instructed that they could not give any cooperation credit unless the company was exposing individual employees, essentially putting them, like I said, into the bullseye of the investigation and identifying individuals who may have contributed to any misconduct that was under investigation. Now, on the defense side, as a defense lawyer, I try very hard not to do that, right? If I'm representing a company, for obvious reasons, I don't want to be pushing individuals into, causing exposure and expanding, the level of exposure that they might have. But what the Yates memo was doing was signaling that if the company wanted to get credit, it was going to have to do exactly that. And so that's why it got so much attention. Now, when we get back to the topic of the podcast, what happens with the transitions? Well, the Yates memo existed throughout the Obama administration. It's still in place, to be clear. But with the first Trump administration took office in 2017, the Yates memo was essentially, call it watered down, but modified essentially to say that while DOJ was and line attorneys were still being encouraged to focus on individuals who were bad actors, it was no longer an all or nothing calculation. The company might not get maximum cooperation credit if it did not identify individual employees, but it could still get some cooperation credit. And this is just sort of kind of meeting in the middle, essentially, if you will, where if a company was unwilling or reluctant to identify or expose individual employees, but was cooperative in every other way, they could still, under this modification to the Yates memo, they could still get cooperation credit and still potentially get a lighter penalty if they were otherwise cooperative.
Thanks, Cormac. Yeah, and what I like about the Yates memo is this is the type of example of a policy shift from one administration to the next. I think this is the type of thing that could happen in the upcoming administration is policies like this one, where you change the way False Claims Act investigations work just at a fundamental level. So that's why we wanted to talk about the Yates memos, because it's a great example, something that fundamentally changes the way these things work. So, Cormac, going forward in time for the first Trump administration, what stands out to me from an FCA policy shift was the Brand memo. Cormac, tell our listeners about the Brand memo, what it did, and then tell us whether you think it's reasonable to expect the return of the Brand memo in the second Trump administration.
Sure. Memos to look at it, like you said, because one came from a political person, one came from a career person, and both ended up influencing DOJ policy. So the Brand memo was issued in 2017 by Associate Attorney General Rachel Brand. For reference backgrounds, the Associate Attorney General, or AAG, is essentially the third in command at DOJ, reporting to the DAG, or the Deputy Attorney General. And in the Trump administration, Rachel Brand was responsible in that role for several of DOJ's components, including the Civil Division. The Civil Division is the component within DOJ that handles FCA cases. So focusing on that Brand memo and what it was trying to do, going back in time, historically, a lot of FCA enforcement is based, as we might imagine, on statutes and laws and regulations. For example, the anti-kickback laws, where if you were to pay a kickback and then try and make claims to the government that would involve those kickbacks, you've committed an FCA violation. And that's the basis for a lot of different types of investigations. But over time, a lot of the FCA enforcement that we were seeing was focused not so much on those enacted statutes and regulations, but on less formal agency guidance documents. And the documents that issue from agencies don't go through formal notice and comment processes. And so, like I said, they're less formal. And there was some question over time as to what weight do these have if you're looking at a company or a person's conduct in submitting claims. If they were to violate a statute, that's one thing, but if they violate an informal guidance document, is that the same level? In the healthcare space, an example of this might be where you have a coverage determination where that Medicare contractors would draft to say that what they'll pay for and what they want. The problem is that before the brand memo, DOJ would bring cases under the False Claims Act that would be based sometimes largely, sometimes partly relying on these agency guidance documents or these informal notices. And a lot of times they would use those as evidence to try and prove that a defendant knew what they were doing. You know, in any FCA case, the government has to prove that the company or whoever's under investigation knew what they were doing was wrong. And so what the investigators were doing in many cases is looking at these less formal agency guidance documents and saying, well, the agency issued a statement saying they think you should do X, Y, and Z. You didn't do X, Y, and Z. Therefore, you knew what you were doing was wrong. And this created a lot of tension on the defense side because, like I said, there was a question as to what weight you had to give these informal documents and whether you had to follow them to the letter, that kind of thing. What the brand memo did was announced that DOJ attorneys could no longer base an FCA action on those types of what AAG brands called sub-regulatory guidance. And essentially what she was saying, and through the memo, what the DOJ policy was saying, is that if an investigator is going to label something as a knowingly false claim, right, that's the basis to start an FCA case, that you think the DOJ must think that somebody submitted a claim and they knew it was false. There's got to be something that's either a statute or regulation that went through a formal notice and comment or the legislative process, something more hefty, if you will, than an informal agency guidance document. That's where the brand memo shifted DOJ policy, is to take those sub-regulatory guidance, as AAG brand described them, off the table as kind of an evidentiary basis for bringing an FCA case. So the brand memo, was obviously a defense and business-friendly development because it effectively shrunk the field as to what could be used by DOJ to bring an FCA case and the types of evidence it could use to prove knowledge. However, the memo did not enjoy bipartisan support. And so when the Biden administration came in, incoming Attorney General Merrick Garland rescinded the brand memo and basically took us back to the days before the first Trump administration, when that sub-regulatory guidance could be used as the basis for a False Claims Act case. So since we are looking now at Trump 2.0, I think there is a very good chance that the brand memo comes back or something similar to it. It's easy to do, right? I mean, the memo has already been written. The Justice Manual and guidance for line attorneys had been modified once before. Then AG Garland changed it, and it could just as easily get changed back. So I do think that that's pretty likely to see a change that we see come back for the second Trump administration, especially because, as we all know, the candidate Trump has been highly critical of federal regulations and administrative agencies generally. So bringing in or restoring guidance from the brand memo would certainly be consistent with incoming Trump administration's policies and certainly politically popular to Trump's voting base.
Thanks, Cormac. That's a reasonable prediction to make to me, that the brand memo in some form will come back. Like you said, it's a very easy thing to do. You don't need to go through notice and comment or anything. You just reissue the memo. It's already drafted. So it's probably a good guess. And Cormac, I think that's a good place for us to pause. So to our listeners, I hope you enjoyed this initial discussion of how a changed administration could impact FCA enforcement. We'll come back very soon to tell you about how FCA enforcement shifted in the Biden administration and how Cormac and I think FCA enforcement will shift in the upcoming Trump administration. I'll talk about how the Brand memo actually impacted what I did when I was at DOJ. And we'll talk about the potential FCA bombshell. Could the next DOJ embrace the Zafarov holding and try to end key TAMs? That's all coming your way on our next episode, coming to airwaves or internet waves, series of tubes. I don't know, whatever. It's coming your way very soon. Thanks for listening to part one. We'll see you next time.